大家
Good morning. It's the appointed time and we have a quorum. Please invite the administration to join us.
咁點解去到嗰個 application？ 上次講到2A 嘅，即係講完2A 嘅，你應該係開始做 application 嗰度，即係0006。2A 上次都講完。
最後先講呢個。好，相信大家咁延續。
This is a continuation of the last meeting. We have received some letters. The first one is a response from the administration to the Hong Kong Airline Pilots Association. The other one is CB bracket 41307/16 to 17 bracket 03. And there is also one that is a response to issues raised in the last meeting. That is a CB bracket 41307/16 to 17 bracket 02. I'll ask the administration to take us through the papers. Our first response paper is in reply to points and concerns raised by the Hong Kong Airline Pilots Association. This is CAB 448B, the Hong Kong Civil Aviation Investigation of Accidents Regulations. It is to determine the circumstances and causes of accidents for preservation of life and avoidance of similar occurrences in the future. We emphasize that the purpose of the investigation is not to apportion blame or liability. Under Section 10 bracket 2 in our proposal, it is made very clear that the investigation will not be conducted in a public setting. And we also point out that in Annex 13.5.12 of the ICAO and Appendix 2 of Annex 3, that is in relation to protection of investigation records, that is witness statements, cockpit voice recordings, airborne image recordings, and any transcript from such recordings. And in March 2017, we issued a consultation paper to the industry. We said that we would conduct a comprehensive review of CAB 448B. In the legislative session 2018-19, in relation to other necessary amendments to dovetail Annex 13, we will make proposals. We hope that we plan to take into consideration the views expressed by the Hong Kong Airline Pilots Association in the second round of legislative amendment. So what about the response to issues raised in the last meeting? Please Just bear with me.
係主席，就住我哋6月3
In relation to our response paper dated the 30th of June to issues raised, the first point is about the Independent Air Investigation Authority. Whether the authority would be in charge of investigation into accidents occurred within the flight information region of another jurisdiction, which is at the same time in Hong Kong's in the flight information region of Hong Kong. Under the Air Navigation Hong Kong Order 1995, that is 448B, Cap 448B, in relation to accidents or incidents that occur to a civil aircraft in or over Hong Kong in Flight Information Region of Hong Kong, we are empowered to conduct investigation. The second point, whether the Independent Air Accident Investigation Authority would be in charge of an investigation into an accident occurred within the Flight Information Region in or of Hong Kong, but in or over another jurisdiction. Perhaps I will switch to English.
Negative, except for the case where the aircraft to which the accidents or incidents occurred is a civil aircraft registered in Hong Kong as provided for in the proposed Regulations 3(2)B2. And in such a case, the provision in the regulations as amended would apply. It should be noted that a flight information region is not necessarily congruent to a country or administration's region. 咁呢個即係簡單嚟講，就係話我哋其實喺我哋嗰個領空，我哋可以係。
In other words, we can conduct investigation in an accident that occurred within the flight information region of Hong Kong when the civil aircraft is registered in Hong Kong. And under the Basic Law 130, it says, I read it in English,
Administrative region shall be responsible for its own for matters of routine business and technical management of civil aviation, including the management of airports, the provision of air traffic services within the flight information region of the Hong Kong Special Administrative Region. 咁呢一度我哋嗰個理解咧就 the provision of air traffic services within 香港嘅 FIR 咧就係我哋睇到就係即係呢個係包括咗就
include ground-based it includes
advice and information useful for the safe and efficient conduct of flights 嚇。咁根據
Under Chicago Convention Annex 11, Air Traffic Service is
Flight Information Service, Alerting Service, Air Traffic Advisory Service, and Air Traffic Control Service. 咁所以我哋將兩個
So if we read these documents together, the provision of air traffic services within the flight information region under Article 130 of the Basic Law refers to civil aviation accident investigation.
你呢就讀咗即係 Article 130 underline。
Well, Article 130, the part that is underlined, the focus is
allocated to it under the regional air navigation procedures of the ICAO。即係我意思就係話air service，我明白，即係上面你話 provide。
I understand that when you refer to provision of air traffic services, it's a generic term. However, the latter part may include investigation. I'm not sure whether investigation is part of the responsibility. And I see that you said Article 130.
字眼都係 unlikely， 而唔係一個好 definite 嘅字眼。
You use the word unlikely, so it's not very certain. So, it's actually the part that is after the underline one that is my focus. Sorry, when I refer to air traffic services and other responsibilities, if we read it together with the Chicago Convention, our understanding is that air traffic services within, alerting, that includes alerting services, air traffic advisory service, and air traffic control service. We believe that they are related to air traffic control. That is that's under the other responsibilities allocated to it under the regional air navigation procedures. After Annex 11, you said, in quotation, air traffic services mentioned in Article 130, which is the underlying part, the provision of air traffic services within the flight information region, so on and so forth. This only stresses the sentence underlined, and I don't oppose to this interpretation in relation to Annex 11. However, there is an emphasis and the discharge of other responsibilities. The part other responsibilities, I wonder whether it includes accident investigation. I'll defer to my colleague.
Thank you, Chairman. Let me add, we have consulted our basic law staff on this, and on Article 130 of the Basic Law, looking at the English version, the internal discussion is within the flight information region of the Hong Kong Special Administrative Region, and that qualifies only the provision of air traffic services. So the member mentioned the latter sentence, the discharge of other responsibilities allocated to it. That doesn't qualify the within the flight information region, that phrase. So our view is that for the FIR in this provision refers to the provision of air traffic services only, and the discharge of other responsibilities should not be done within the FIR. So our initial understanding is that this provision will unlikely impose the responsibility of Hong Kong to undertake investigation outside of Hong Kong within the FIR, but then not an area over and above Hong Kong. So this is what we're trying to say in our reply. So this is our understanding. Okay. Yes, please continue. The last issue raised by the subcommittee is that whether the proposed authority will be in charge of an investigation into an accident involving a civil aircraft and military aircraft. And in our reply, we set out our view in paragraph 5. For the Chicago Convention, it is applicable only to civil aircraft and shall not be applicable to state aircraft, including military aircraft. So, if we invoke Annex 13 to conduct an investigation, it will not cover military aircraft. So say, if there is an incident involving a military aircraft in accordance with 448B, we can only actually investigating into the civil aircraft part. Okay, so that's our response. Any other question? If not, then there is another letter submitted by the Hong Kong Airline Pilots Association today, and it repeats the points made last time. They set out the list of countries and the protection that they are affording, and they are in support of the government's reply. So I don't think there is a problem there. So the administration, please note their letter, and a later review exercise, please take on board their views. All right, any other question? If not, then we can move into the continue with the clause-by-clause scrutiny, which started last time. If my memory serves right, we were up to 0006. I think my record is that we have finished scrutinizing page 0006. So we'll start with 0007 this time. Please continue. Chairman, page 0007 involves several amendments. The first one is on part 2, the heading. We will repeal accident investigation and substitute it with investigation of accidents and incidents. So accidents and incidents will be included here. Well, let's use the English version if possible. Okay. Then we amend 5, Regulation 5, and that has to do with duty to furnish information relating to accidents. We will replace it with notice of accidents and incidents. This is a textual amendment. There is no change in the meaning. And then bracket 2, 5. We are deleting all the wordings in bracket 1, and then we are making some textual amendments. You can see that
in command, or if the pilot in command is killed, 等等等等呢啲咧，其實亦都係一啲嘅主要係一啲嘅文本。
These are really textual amendments. You can look at the left, the part on the left. We are just putting the whole paragraph in bullet points. And there is one particular amendment here, and that is when the pilot in command goes missing, then the operator must give notice of the accident or serious accident to the chief inspector by the most suitable means of communication available. And put simply, if something unfortunate happens to the pilot, then the responsibility falls on the airline or the operator or the aircraft owner. They have the responsibility to report to the chief inspector. So we are just plugging a loophole here. Okay, if there is no further question, let's move on to page 0008. There is a series of amendments, including 5(2), and in the first part, we add a notice to the chief inspector referred to in paragraphs 1 and 1A, because we have added in a new 1A, so that's a textual amendment. There is no change in the meaning. Okay, and then 5(2), sorry, Mr. Kenneth Leung, for 1A, the new paragraph 1A, occurring or on or adjacent to an aerodrome. What is the point of adding that it? Do you want to be more detailed or what? Or was there originally? Your paragraph 1A is an expansion of a very condensed paragraph 5(1), and you are adding in 1A here. So the wordings have not changed. I just want to confirm this. No change. This is just putting it in points, point form. All right. Please continue. Okay, let's go back to 0008. And then in 5(2)(A), that is corresponding to Annex 13 on the notification of serious incidents. And for an accident, we call it ACCID. For a serious incident, it's called INCID. So this is following the Annex 13. And then (2)(B), we are also copying the wordings from Annex 13 in relation to accidents and serious incidents. And we are giving out the details here, detailed information. Originally, we had type, model, and the nationality, and now we're adding in something a bit more: manufacturer, model, nationality, registration marks, and serial number. So that echoes the wordings in Annex 13. And then we have 5(2)(D). We are replacing it with the name and qualification of the pilot in command and the nationalities of the crew and passengers. And that also echoes Annex 13. But I must stress here that we are also retaining the name of the pilot in command here. In Annex 13, while the name of the pilot in command is not required, but then in our investigation, we think this is a necessary piece of information, so we are proposing to retain that item here. And now we have 5(2)(E), and that is also amendment made in response to Annex 13. So the scope of the time also covers serious incidents. So we have time, local time, or coordinated universal time of the accident or serious incident. It's just adding the phrase serious incident here. And then 5(2)H. Roman letter 1 and 2. After accident, we are adding or serious incident. So that's it's also along the same line that I've talked about. Now we have, we go to page 0009. And the first part here is a description of the accident or serious incident, we just add in the words serious incident. So the regulation also covers serious incident as a result. Yes, please continue. And then 5(2), Roman letter 1. Based on Annex 13, they have the certain specifications on the notification of serious incident. So we are adding in the description on the damage of the aircraft in the incident. We are adding in the description of the accidents or serious incident and the extent of the damage to the aircraft as much as possible. Okay. 5(2), bracket 1, we're adding in amendments on accident or serious incident, and we are adding in J and K. So after accident, we are adding in the words serious incident, bringing the letter into the scope of the regulation too. And then 5(3), again, if an accident, then we just also add an incident occurs. So we are adding the word incident here. So the regulation also covers incident as a result. And then we move on to page 0010. Again, it's a very simple amendment. We are changing the word accident in the heading into accidents and incidents, bringing the letter into play as well. And then also for the wordings below, after information relating to an accident, we just add in or incident. And then we also have a clear, detailed description whether or not the incident or accident is the subject of a board of review of a public inquiry. So let's pause here. I would like to seek a clarification. Now the English version is that is the subject, and then the Chinese is 關乎意外或事故的資料，不論該意外或事故。
即係所有。
I would like to know whether it means that all the investigations into accidents or incidents will not be disclosed. Are you referring to this point? As far as I understand that previously a lot of things were not disclosed, but the way it is read that they can be disclosed. So I wonder what the extent is. Once it's decided that the investigation is not to be continued, do you have to make an announcement that the investigation is terminated?
OK。不如 KC 你答一答。主席或者我。
Perhaps I will defer to Mr. Mann. 5. It's about the responsibility to notify and to disseminate information. What information is to be passed on to the investigation authority? I think you're referring to 6. Yes.
呢個係咪講緊一開始調查嗰個？係嘛？即係成日宣佈話開始調查嗰個呢排㗎嘛？係即係總之未進入詳細調查之前就可以咁調查呢樣嘢。主席係唔好意思啊。
My apologies. When it comes to accidents or serious incidents, if investigation starts under 448B, then we will have to first start an investigation. You may recall a recent incident involving an aircraft slipping into the lawn of the runway. I think a couple of weeks ago we started the preliminary investigation, setting out the causes and the circumstances. It says here that the chief inspector may, at the time deemed appropriate, make any publication or published information or make an announcement. I think that refers to a situation like this. Well, let me read the Chinese and the English version together. For Chinese, 是否調查主任進行調查的標的? It's not very clear. It says that you may publish a piece of information, even that is not related to the subject of an investigation. I don't really understand the word 標的. Perhaps I will refer to the law draftsman. Thank you. First, in reply to your previous question, if an investigation is terminated, whether an announcement has to be made, you may refer to Section 10 of page 15. We will get there shortly. And it says that a public notice has to be published if there is a termination. In general, when it comes to drafting, we use the word 標的 to refer to subject. So if you refer to the English version, whether or not an accident is the subject of an investigation or a board of review of a public inquiry. So the effect of Section 6 is that the chief inspector may at any time publish information, whether or not the accident is the subject of an investigation or a review. If necessary, the information can be published. That is to empower the chief inspector. What is the board of review? You will find the information in later provisions. Perhaps, say for example, a party asks for a review on the result of the investigation. A board may be convened. Perhaps we can continue. Let's move on to page 11. Page 11 is to change section 7 and 8. More textual amendments. Say, for example, to change verbal sentences to points. Say, for example, section 7(1)(b) and 7(4). The functions and powers of the Secretary General of the CAD is moved to the Chief Inspector to enable the latter to authorize some people to make contact with parties who are involved in the accident or incidental removal of aircraft. You can see it in 2E. Questions? Mr. Leung. It only mentions police officer and customs and excise service officer. Why only 2? Of course, this is not an exhaustive list. Is that right? Then, why do you even bother to mention police officer and CNE officers? That's also a question I would like to ask. Mr. Mann, let me give you an example to illustrate. Say China Airlines 1995 incident that happened in the airport. Police officers cordon off the site and the aircraft, and customs officers remove cargo from the aircraft. So they have some special duties. That's why they are set out here. What about the fire services department? Can they move items or objects? Usually, the airliner will engage a party at a fee to deal with the removal of items. Well, 7(4), authorized person. It's just like what Mr. Leung said, is a general term. We highlight police officers and CNE officers because that's so stated in the original provision. If we take them away, it may cause ambiguity. This part says that if the chief inspector thinks a person may be authorized, then then power can be given to them. 7(2)(a) to E. Says that people who are involved in the rescue may deal with the wreckage. Say, for example, the different circumstances set out in A to E. I think that's all right to say it like that. But there's something that I don't understand. Say 7(2). It sets out all the circumstances mentioned by Mr. Mann. Is already dealt with. Then how come there is authorized person appearing? It says means a person authorized by the chief inspector, either generally or specifically to have access to any aircraft involved in an accident or serious incident, and includes. Does it mean that if it's not under a circumstance set out under 7(2) and an object has to be removed, then the person has to be authorized by the chief inspector? Or is it the case that if it's a police officer or a CNE officer, then they don't have to go through the chief inspector before removing an object? Who is to take the question? Mr. Mann? Well, in a consent document of this under the Security Bureau, it sets out the various responsibilities under the purview of different departments. The department can take up the duties set out in the document, and that covers the FSD, police. The spirit of Section 7 is that should there be an incident, say for example there is aircraft wreckage, the wreckage cannot be moved or accessed without good reason, for fear that something may be changed or destroyed. So not everyone under Section 7 can have access to the damaged aircraft to do something. Of course, where there is an accident, it's most important to allow rescuers to have access. So subsection 2 sets out some possible circumstances. Of course, well, people or animals will have to be extricated. Mails, valuables, dangerous goods will have to be removed before it explodes. And in some other circumstance, say for example, there is a risk of fire or potential hazard to air navigation, we set out certain circumstances to allow certain duties to be carried out before authorization is given by the chief inspector. I'm sure no one will object to it, because when it comes to a rescue, it will be police officers. When dealing with dangerous goods, it will be the CNE.
So no arbitrary access should be provided, but then if in cases of emergency, people can invoke 7.2 to do something. And 3 is a special circumstance. If an aircraft is wrecked on the water, well, it is difficult to drag the aircraft out of the water. So this is a special scenario here. And for 7.4, the intent is that for the police officers and the CNE officers, they normally arrive at the first instance at the site. So they may not need the chief inspector's special authorization before they can do their rescue work. Now, for the aircraft wreckage, it may become an evidence for investigation. So no person can try to gain access to the aircraft arbitrarily afterwards. So 7 has to do with how we deal with the wreckage of the aircraft. I totally agree with every word you said just now. But the question is, for 7 here, it can do something which is outside what you have talked about. If you look at 7 bracket 1a, it is said that no person other than an authorized person may have access to the aircraft involved in the accident or serious incident, right? That's very clear. And B, neither the aircraft nor its contents may, except under the authority of the chief inspector, be removed or otherwise interfered with. This is again very clear. But then for 7(2), it lists out all the scenarios in times of emergencies, and this is all very reasonable, fully agree with it. And for E, removing other property from the aircraft under the supervision of an inspector or with the agreement of an inspector or police officer. I don't understand that. Why? A police officer at that juncture has the authority to remove the property. And then in 4, it is said that this authorized person is there. So does it mean that it's inclusive? As long as you are a police officer and customs exercise officer, then you are automatically an authorized person and no special authorization is needed. Is that the case? Or does it mean that any police officer and any customs and exercise officer is already automatically an authorized person? And then that takes us back to 7(1)(b), because it says that except under the authority of the chief inspector. Does it mean that these two categories of officers have been automatically authorized, and so 7(b) is not applicable, right? So can I ask the legal advisor to say something? I understand the chairman's query. I try to explain this amendment regulation here, and I'll see whether the government lawyer agrees to my view. I understand the chairman's confusion. When I read through this provision, my understanding is that the premise is that unless there is authorization, there are two ways of authorization. One is general authorization, and then there is this special authorization under the amendment regulation. So under these two types of authorization, apart from these authorized persons, no other person shall have access to the aircraft involved in the accident or serious incident. And then in 7(2), we see the exception cases. These are the exceptional cases. The chairman is very concerned particularly about E, and that is under the supervision of an inspector or with the agreement of an inspector or a police officer, remove other property from the aircraft. And the chairman's concern is the police officer's agreement is needed. So does this police officer need an authorization or not? My interpretation is that because this is an exception, so the police officer doesn't need special or general authorization do this. Now, if something happens outside of the 5 scenarios in bracket 2, then any police officer or C&E officer and any other person should need the general authorization or special authorization from the chief inspector before they can have access to the aircraft in the accident or serious incident. So that's my reading or interpretation of the provisions. I'll see if the government lawyer has any other views. I'd like to thank the legal advisor's interpretation. I agree to that. Now let me add, 7(4) is just a way to try to draft the matter, and it's a definition clause, and it is to define what we mean by authorized person. As what the chairman said, the police officer and the customs and excise officer are automatically authorized persons, and they don't need the chief inspector's special authorization, because they are already authorized persons in their capacities. So in relation to 7 bracket 1, well, they can fit into that the authorized person in that provision, and then they can have access to the aircraft automatically. And as what the legal advisor said, at 7 bracket 2, they are exceptional cases. Say, if the air hostess or any other person, she is on site and she is not an authorized person, and she doesn't get authorization from the chief inspector. But then if the scenario is one of those 5 listed in 2, then no matter what capacity she is in, she can do something. But particular for 2E, then we need the police officer or the inspector to supervise the act or before the air hostess can remove certain property. So that's the interpretation of the provision. So police officer, does it encompass all ranks or refer to a particular rank? What about police constable? Are they included? Ms. Ng? Give me some time to check into whether there is a definition. But to my understanding, well, there is no, special reference to a particular rank. So I'll see if the legal advisor has any view on this as well. Legal advisor? Thank you, Chairman. If we look at 448B, my understanding is that, well, when you look at the definitions of that regulation, we don't see any definition on the police officer. So that's how the definition part of the regulation is like. No definition there. Now for IGCO Cap 1, Section 3, there is a definition to the police officer. There is a general definition. Well, maybe allow me to speak in English.
Terms or expressions referring to ranks in the Hong Kong police force shall bear the meanings respectively assigned to them by the police force ordinance. 咁似乎即係可能詳細都要再睇翻嗰條 police force ordinance，但係就咁睇落去似乎。
We'll have to look at the police force ordinance to see what the details are, but then it seems to be a general term here. Well, my greatest worry is not about the rank of the police officer involved, because there is a difference in the wording of this provision compared to my understanding originally. So after an accident happens, no person should have access to the aircraft except say that you are to rescue somebody, you want to remove certain properties and so on. But then going by what the government lawyer said just now, it seems to be otherwise. And that is to say, these 2 types of officers, police officers and the customs and excise officers, are automatically authorized persons. And they can, for reasons other than those listed in 2 A, B, C, D, E, get access to the aircraft and remove certain things. So that's my greatest worry. I'm not saying they will have a sort of ulterior motive of what, but then they don't come from professional backgrounds as far as investigation is concerned, and they may have removed some important items, and they are unaware of this, which will affect the investigation. So I have, if this is really the case, then I have a great concern. We understand the meaning or the intent of the provision, but the way it is written is creates problems, because police officers and customs officers can remove properties without the approval of the chief inspector. Well, they don't even have to do it themselves. They can authorize somebody else to do it for them. Because for 7(2)(e), the other persons can remove the property under the agreement of the inspector or the police officer. So somebody else apart from the police officer can remove the property. So that means the PC can remove certain objects, right? Because they have a comma here, so it's or, the word here, there. So it's the or with the agreement of an inspector or a police officer. There are 3 ors.
可唔可以講呢度啊？唔該，秘書長。
So can you explain this? Well, when we investigate into an accident, every time the inspector will be there to supervise the investigation. Of course, well, he will be there at some time, but he will not be there around the clock. So maybe the security personnel and the police officers may cordon off the area. I believe that will be the case. Now, when the inspector is not there, police officers may be there, and they may believe that, well, let's remove some properties. Maybe they are standing in the way of the passageway for safety reasons, and they remove certain items. But then these items prove to be very important later. So I think we're not talking about the probability of having that scenario. I think we're talking about a matter of principle here, and they should not fall under the 72 D and E or E. So let me repeat. Whenever a police officer removes any piece of evidence, and that should be under the supervision of an inspector. Well, that differs from what you said. Well, this is what we want to see, that is only under the agreement of an inspector can the police officer remove certain properties. But then that's not what the legal advisor or the government lawyer said, because the police officer can remove certain properties without telling the chief inspector. That is my greatest concern. Why I appreciate your concern. Well, going by the wordings here, there may be a possibility, no matter how slim, that this will happen. But you have to understand that in the course or in the process of an investigation, the chief inspector will supervise the whole process. Will what the chairman said happen? Yes, going by the wordings, that may happen. But we've conducted so many investigations in the past, and never has a police officer in whatever rank took away something and then didn't tell us, just because he was the authorized person. Well, we don't see that kind of possibility in actual operation. And whenever there is an accident or serious incident happening. Right now, it would be the Director General of the Civil Aviation who is spearheading the exercise. Now, after the amendment regulation is passed, it will be the Chief Inspector. So whether it's the police, the government lab, personnel, and so on, we will work as a team, and we will support the investigation of the Chief Inspector, because the Chief Inspector has the statutory duty to conduct investigations into accidents. Now, just looking at the wordings here, maybe I will not be able to allay Chairman's worry totally.
But when it comes to the actual conduct of an investigation, I don't think what you have said, Chairman, would actually happen. Well, we understand your intent. But since there is amendment, why don't we make it very clear? Because they have already been authorized by the law. You can't say that, well, today it's our legislative intent, let's forget about the wording. You can't do that. It's about how power is given to the Chief Inspector. You want to give the power, all of it, to the Chief Inspector under this amendment. I do have a problem with the wording. Well, if it's just a discussion without referring to the legislative change, that is fine. A police officer is naturally a law enforcement officer. And of course, it's okay that they carry out the investigation. I'm not trying to change the power enjoyed by the police at the moment. But you can't just say that this is the legislative intent. I understand your concern, and when it comes to police officer and officer of the Customs and Excise Service, these terms are already in the original provision. You can find it on page 11. Means any person authorized by the director, includes any police officer and any officer of Customs and Excise Service. We add certain things to it pursuant to Annex 13. I'd like to say that I do understand your concern. In some extreme circumstance, what you have said might happen. But if it is in an extreme circumstance, any authorized person, whether it's a police officer or CNA officer, might still do what you said they might do in an extreme circumstance. Well, it's a general authorization saying that in relation to investigation of the accident, you may have access and come into contact with evidence. This is opposed to specifying individual acts. You have to be authorized. You have to be given a general authorization, be able to carry out these acts. However, if that's the concern of the chairman, perhaps it will be included in the review for the legislative exercise in 2018-19. I agree with what you said. Well, as explained by the PS, and I don't really mind whether it's stated, because the chief inspector has already implicitly said that authorization has been given to police officers and CNA officers. My suggestion is that in the next legislative exercise, if these authorized persons remove items, then a report will have to be prepared, and it can only be done with full justification. Say, for example, this collection of evidence for an investigation. If you leave it, then the evidence may disappear. I see that why you say that there is a loophole, because a general authorization is given to these two groups of people. Mr. Kenneth Low, I'm not talking about any extreme circumstance. For 72A2D, it has covered different circumstances for rescuers, FSDs, police, CNEs to deal with properties in the wreckage. Yes, I know that in the original provision it says the director of the Civil Aviation Department has already given authorization to police officer and CNE officers. That means a police constable that's just graduated can decide whether to remove evidence from from the scene. Yes, I heard Mr. Frankie Yik. The chief inspector can immediately authorize these departments to deal with the wreckage. A decision can be made instantly. You don't have to cover police officers or CNE officers under this subsection. Well, it may say that the government flying service, the FSD, and some discipline services involved in the rescue can be covered by the authorization. It may even cover overseas rescue units that comes to Hong Kong to help. I think that's our general concern. You said you may focus on this in the exercise in 2018-19 to possibly tighten it up. Then you will have to ask yourself what can happen and what you don't want to see as a hindrance to rescue. I fully subscribe to what Mr. Leung said. We need to strike a balance. Of course, lives and valuables should be preserved and rescued. When it comes to removal or collection of evidence, I think it's more to do with more to do with investigation. And we're talking about two different scenarios. And I think the premise is not to hinder rescue, to allow some people to access the scene to remove items or to access the wreckage. We have to be more cautious. Perhaps like Mr. Yik said, when something is removed, it has to be recorded. I'm sure that is currently in place, but whether we need to reflect this under the law, we need more time to look into it. If you refer to the previous version, I say it in Chinese. Well, authorized person, the expression means any person authorized by the director, either generally or specially, to have access to any aircraft involved in an accident, and includes any police officer and any officer of the CNE service. That means the director would authorize people, and these people would include these people. So they still need an authorization. It's just that it's generally put that authorizations given to these people that include police officers and CNE officers. However, after the change, it gives the impression that an automatic authorization has been given to police officers and CNE officers. That's my problem. That's the problem I have. Your interpretation of the provision may not be correct, because under subsection 2 it says, however, it generally includes police officers and CNE service. So the director does not have to specifically give authorization. It's just that it's moved over here and is broken down in more detail. If you all agree that this will be looked at in the exercise in 2018-19, perhaps we'll just leave it at that. I agree. Just now the PS has already said that rescue and investigation are two different things with different requirements. Perhaps in your review in 2018-19, you may consider whether to take them apart and write in greater details about these provisions. We will continue. Page 12. This part deals with inspectors, their powers, and also the scope of responsibility. the textual change is to add the concept of incident. And under 8 bracket 2 and 3, we have set out that the Chief Inspector is accountable directly to the Secretary for Transport and Housing. And together with inspectors, they form the Accident Investigation Authority, which is under the Transport and Housing Bureau. This is to highlight the fact that the authority is independent from the Civil Aviation Department and is directly under the THB. 8 bracket 2. Well, the current provision states that the Chief Inspector shall determine whether or not an investigation shall be carried out to which these regulations apply. So the Chief Inspector has autonomy over whether an investigation is to be carried out under 448B. And in bracket 4, it specifies that the inspector is to ensure that investigation into an accident or serious incident is carried out.
Investigation into an accident or serious incident is carried out. 呢個無疑就係話將一個法定嘅
That is, there is a statutory duty given to the Chief Inspector. When the Chief Inspector is aware of a civil aviation accident or serious incident, then investigation has to be carried out. And in 4 and 5, it sets out that the Chief Inspector, whilst making sure that an investigation into an accident or serious incident is carried out, it may also carry out an investigation that into an incident. That is in line with the spirit of Annex 13. An investigation is to enhance aviation safety. I remember, Chairman, that you were concerned about this. You see that this provision states very clearly that the Chief Inspector can also decide to carry out an investigation into a minor incident on top of accident or a serious incident. Under subsection 7, well, the Secretary General of the CAD's power to investigate is now moved to the inspector. Is now given in whole to the Chief Inspector. Now we will move on to page 14. First, 9 powers of inspectors. We have changed from accident to accident or incident. We have already covered that.
And 9 bracket C. And we change accident to accident or incident and the place where the incident occurred. So we're adding in the concept of incident here. And again, in 9D, Roman letter 1, after accident, we add in or incident. So it's the same here. 0015. Regulation 10, the heading. Well, the original heading was Inspector's Investigation Report, and there was a textual amendment. We changed it to Investigation. It doesn't carry a change in the meaning. And 10, bracket 1, Please go on. Again, it's a textual amendment.
OK， 我哋只不過
Inspector's investigation has been changed to investigation, and the law draftsman think that's a clearer expression. And now we go to it's 10.
OK。呢條第12 ，yes 冇錯嚇，係主席對唔住，去到第
Sorry. 10(2) again is a textual amendment. (3) Inspector will be replaced by Inspector in charge. That will set out clearly the powers of the Inspector in charge, which will allow him to examine witnesses and call evidence. We move on to 10(4). And that is to the responsibility of the DGCA in granting allowance to witnesses. This power is to be transferred to the Chief Inspector. So that is in line with transferring powers of the DGCA to the Chief Inspector, as I mentioned earlier. Now we move on to 10, 5, and 6. The provisions related to the director will be deleted. And then we will allow the Chief Inspector to decide an investigation or into an accident or incident be discontinued. As what the legal advisor said, if an investigation is discontinued, the Chief Inspector must give public notice. So the powers now vested with the director will be transferred to the Chief Inspector. I have a question here. He must give public notice of the discontinuation of the investigation. Is there a time limit for him to do so? Now, if I say I discontinue the investigation now, should I make the public notice, say, in 1 month, 2 months, or 3 months' time, or what? There is no requirement on the timing. Would that be a problem? Maybe this is an incident of public concern. Well, later on we'll see that the CE will have the power to discontinue an investigation. Let's discuss it later on. If this is an incident of public concern and the investigation is discontinued and the Chief Inspector doesn't give public notice and there is no time limit for him to do so, so he can do so, say, after 3 years, and that's going to be problematic. Chairman, the Chief Inspector will be involved in investigations, and for every investigation, many different units will be involved. For example, the aircraft, say if the overseas aircraft has an accident in Hong Kong, then the manufacturer and the overseas jurisdictions will be involved. So many parties will be involved. And if the chief inspector discontinue the investigation for one reason or another, I am sure that he will announce this in the shortest possible time. Chairman, you said the Hong Kong public are concerned about a certain accident, and I'm sure that apart from the public, many other parties will also be concerned. So we must allow the chief inspector to do so, or to make the public notice in a reasonable time. All right, please continue. Let's move on to 0016. And that is on investigation report and the arrangement for that report. And in 10A bracket 1, we are actually replacing 10.6 by this. And we are saying that the chief inspector will make an investigation report to be submitted to the chief executive. And 10A2 sets out the information or rather we would add in incident on top of accident. So we are adding in incident in 2A, C, and D here. Well, for the submission of the investigation report to the chief executive, this post should be directly accountable to the Secretary for Transport and Housing. Should we submit the report first to the Secretary for Transport and Housing before it is submitted to the Chief Executive? Chairman, the investigation report will be submitted directly by the Chief Inspector to the Chief Executive. When that is done, our current thinking is that the report will also be submitted to the Secretary in parallel, because after all, the Secretary is responsible for the civil aviation policies. So for investigation results of an accident, he should be notified duly. But the amendment regulation sets out clearly here that it is the chief inspector who is submitting the investigation report directly to the chief executive. I have a question. For the STH, he is his direct superior. So you said that the report will be submitted to the STH in parallel, then that's all right. But if you say that the report should be submitted first to the STH for his scrutiny and for his revision, then it will be submitted to the chief executive, then that's going to be problematic. The STH is responsible for civil aviation matters. We want to have this chief inspector to be an independent post, and we have to make this post very independent. Now, in this amendment regulation, there is no role for the STH whatsoever. So I would like to confirm whether this is really the case. Yes, the STH will definitely not amend the report made by the chief inspector. Well, now the DGCA is taking up the post of the chief inspector now, but then so far the STH has never made any revisions to such investigation reports. Okay, let's move on to 0017. In the heading, we change inspector's report and representations thereon to report and representations. So amendment in the text, no change in the meaning. And in Regulation 11, we made amendments to subsection 1. And that, again, is a textual amendment. There is no change in meaning. Okay, please go on. Okay, 0018. Textual amendment again. No change in meaning. All right, understand. (11)(4). We have repealed the provisions relating to the director. We just replace it with inspector in charge and delineate his role. And then under paragraph 1 or 1A, because there have been amendments to 1 and 1A, so this is the consequential amendment. And page 0019, and that is on the notice of review. Bracket 1, we would add in 1A, because there was, that's again a consequential amendment. 12, bracket 1, we replace the word director with chief inspector. I think that should be clear. And then 12(4), we have added an inspector in charge here. Page 0020, appointment of Board of Review. Subsection 1. We have replaced director with chief inspector. And the 1, bracket A, a magistrate, a legal officer, with, we have replaced it with within. Change in the wording and no change in meaning. Bracket 3. The inspector served a notice under Regulation 11(1). We'll change it to a notice has been served under Regulation 11 bracket 1 or bracket 1A. So that again is because of the changes previously to 1 and 1A. And we change inspector who made the report under 4 and change it to inspector in charge. That's a reflection of our early discussion. And 14, proceedings of Board of Review, bracket 1. Inspector has been changed to inspector in charge. And for 5, A, B, and C, change in the wording only, including changing director into chief inspector and changing R into is. These are minor textual amendments.
咁喺第00
Now, page 22. Inspector becomes inspector in charge. So there is no change in the meaning. Page 23. Publication of reports. The word inspectors becomes investigation. So it's just a textual change. 15 bracket A, 1A is added after 1, just to reflect previous changes. Next, reopening of investigation or review is only a textual change to delete the word inspectors. Page 24. This is about holding of public inquiries. This is also a textual change without changing the meaning. Page 24, I have a question. 1A. The chief executive may terminate an investigation. Well, there are two things here. They may terminate it and turn it into a public inquiry. Well, in the first place, does the chief executive have the power to ask for a termination of the investigation held by a chief inspector without holding a public hearing? I'll defer to the law draftsman. Well, if the chief executive is of the view that a public inquiry has to be conducted, and in that case, an investigation of the chief inspector has to be terminated. It's not the case that the chief executive can do it at will. So if there is a public inquiry, then the investigation of the chief inspector may be terminated. Let me defer to the law draftsman. I agree with the members' understanding. That is the current legislative legal effect. The chief executive cannot directly terminate an investigation. It's only after a commission has been appointed that under 1A an investigation is terminated safe and except under subsection 3. Subsection 3, although not amended, is also related to our concern whether statements or information may be passed on to a relevant enforcement agency. So you need to consider this as well. The last change under section 17 is to change the word commander to pilot in command. Is just to clarify the delineation of power and responsibility. Now, page 25. These are just textual changes. Before inspector, the word chief inspector or and is added to clarify the role of the chief inspector. And then subsection 12. Sorry, please pause there. Legal advisor. Thank you. It won't take up much time. Is to let members know that in subsection 12, that is section 17 subsection 12, when I vetted the amendment regulation, I talked to the law draftsman. I'm referring to the markup copy of the Chinese version. Well, there are 3 textual amendments here. I'd like to draw members' attention to this. The deletion of bracket 1 and replace it with bracket 1A. At the same time, there is an amendment of a larger extent, that is, inspector's investigation into an accident. We see a large chunk is deleted and replaced with another chunk. The amendment to bracket 1 is repetitive because of the chunk of amendment that follows. Members, I'm not saying that they can't amend it, but this amendment is not entirely meaningful. I'll leave it to the law draftsman to consider how to amend it. Perhaps I will defer to Mr. Feng. Well, the changes to subsection 12 under section 17. The Chinese version has to be amended in a corresponding way to the English version. So the replacement of 1A to 1 is just that the sentence structure of the English version and the English version are different. So you see that in bracket 6 you see is different from bracket 5. This is to achieve consistency. It's only a difference in the sentence structure of English and Chinese sentences, and it gives the impression that it's repeated. Please continue. Next, page 26. Well, to add the word or incident to accident, it's subsection 5 under section 18. There are two changes. Page 27. It's just a continuation of section 18. Now we move on to page 28. First, the heading, to add the word or incidents I've explained before. Subsection 1, we propose to delete it and replace it with new 1 and 1A. The function of the Secretary General, that is to appoint competent authority of another country, and we have changed it to this power is changed to Chief Inspector. Next, page 19, the Inspector is changed to Inspector in Charge, Directors changed to Chief Inspector. Page 30. This is to add a transitional provision. It states that investigations being conducted before the effective date of the regulation will continue to be investigated by the Chief Inspector. This is to ensure that ongoing investigations or evidence and statements obtained will continue to be effective under the new provisions. Mr. Kenneth Leung, the transitional provision. You mean, say, well, when an investigation was started by the director with the new proposal being implemented, it will be taken over by the chief inspector, right? This is to ensure that there is no vacuum period. Legal advisor. Well, let's continue. No, there are no changes on page 31. Now let's move on to 448 subleg C, consequential amendment. Page 1. Let's refer to page 2 because you don't see any changes on page 1. Well, hold on. 37 bracket 1. From when will there be any recordings of the flight data recorder? I say that is not from takeoff to landing run, is from the start and stop of the engine. You may please consider it in the next legislative exercise. Yes. And in 37(2) bracket B, it includes takeoff, climb, cruise, descent, approach to landing and landing. It has excluded taxiing. Perhaps, apart from subsection 1, you need to consider B of subsection 2. Let's move to page 2 of 448C. Textual amendments only. To add or a serious incident after accident. Page 3, no change. Now we move on to page 4. Subsection 2 under B, provided that an accident, we add or a serious incident to expand the scope to serious incident.
Okay, so
There is no change in page 0005. So for members' reference, you may notice that for 448C, there is no Chinese version. And on this, we have talked to the administration, and we understand that the government is doing preparatory work. And at an appropriate time in the future, the Chinese version of 448C will be compiled. Do you plan to come up with a Chinese version of this? Do you have a timeline? Chairman, we will come up with a Chinese version ASAP. Do you have a timeline, next legislative session or what? Let me put it this way, because we will be doing the second stage review, and the 448C may also be involved. So please allow us to work on the second stage review before we work on that. For the second stage review, what pieces of subsidiary legislation will be involved? Roughly speaking, can I defer to Mr. Shum? 448B, second stage, for Annex 13 this time. Well, it's been some time since the last amendment was made to 448B. So if we want to be in line with international standards, we have to amend certain other parts as well. Apart from the matters discussed in the previous meetings, we will also be working on, say, the data 448D, safety data. If safety data have to be disclosed, who or which authority will be empowered to do the balancing test for the disclosure? Which unit will be responsible or will be empowered to disclose certain information? And also, there will be a penalty to be worked on. Right now, we don't have a penalty on 448B. So these are the three things that we will be working on: protection of investigation data, balancing test, and also penalty. There will be other matters as well, but these are the main issues to be looked at. Okay, any other question from other members? So if not, then we are finished with the scrutiny. Well, thank you very much. And on Wednesday, I will be applying for an extension of the scrutiny. And we can discuss this at the council meeting on the 11th of October. And a report will be made on the 6th of October at the House Committee meeting. And if members have any amendments, they should do so, move the amendments by the 3rd of October. Thank you very much.